Lakshmi Rathar, Registrar General of Odisha High Court, with utmost humility and respect, now seek the kind permission of Your Lordship, Honorable the Chief Justice, to formally declare the function open. Thank you, Lordship. The proceeding is declared open. It is my privilege to extend my respectful and warm welcome to the Honorable of the High Court of Odisha present on this occasion. I also extend a cordial welcome to the Director, Odisha Judicial Academy, the Principal Secretary to Government of Odisha Law Department, the Member Secretary, Odisha State is across the state, the panel lawyers and the paralegal volunteers joining us physically and virtually. The nodal initiative of Honorable Supreme Court, Samadhan Samaroh, reflects our collective commitment to promote mediation as an effective, accessible and human method of dispute resolution, particularly to foster trust and cooperation between the state and its citizens. The success of Samadhan Samaroh depends greatly on awareness and participation. Programs like this play a vital role in sensitizing stakeholders and spreading the message among the general public.
And a very good morning to everybody who are present in this hall as well as joined us virtually and watching this program. This program is being arranged as a part of sensitization and deliberation for achieving the best result in Samadhan Samaroh 2026, a special Lok Adalat which is being organized by Honorable Supreme Court. Honorable Sri Harish Tandon, the Chief Justice of High Court of Odisha and Patron-in-Chief State Legal Services Authority Odisha, OSALSA. Honorable Sri Manas Ranjan Pathak, Judge High Court of Odisha and Executive Chairman OSALSA. My sister and brother judges present here. Dr. Bhagyalakshmi Rath, esteemed Registrar General and other officers of the Registry of the High Court of Odisha. Dr. Pavitra Mohan Samal, Principal Secretary, Department of Law, Government of Odisha. Mr. Arvinda Patnaik, esteemed member, Member Secretary and other officers as well as support staff of OSALSA. Sri Vidyut Kumar Mishra, esteemed Director, Odisha Judicial Academy and his team. Sri Satyabrata Mishra, esteemed Coordinator, Arbitration Center, High Court of Odisha. Mr. Pranab Kumar Patra, LR Special Secretary, Department of Law, Government of Odisha, as well as nodal officer and other esteemed nodal officers of the state government. Learned secretaries of the District Legal Services Authority of different districts, panel lawyers, Legal Aid Defense Council and PLVs of all the districts of state. All the stakeholders of Samadhan Samaroh 2026, my dear students of different law colleges and universities, members of print and electronic media, officer and staff of Durdarshan Odisha. Ladies and gentlemen, I welcome you all to this special sensitization program organized by OSALSA. Samadhan Samaroh 2026 is a special Lok Adalat organized by Honorable Supreme Court of India to facilitate and assist the parties to resolve their disputes pending before Honorable Supreme Court through mutually accepted settlement. Honorable Supreme Court also prepared a SOP for seamless and effective settlement of disputes in the Samadhan Samaroh 2026. It aims at participative justice and doorstep delivery of justice, which indicate a revolutionary institutional initiative by Honorable Supreme Court making a shift from adversarial litigation to collaborative mediation. It has three distinct stages such as preliminary, onboarding and final stage. We all are aware that Samadhan Samaroh 2026 commenced on 21st April 2026. The special Lok Adalat will be held at Supreme Court of India on 21st, 22nd and 23rd of August 2026. I am informed that 1719 cases have a successful settlement of disputes. I take this occasion as an opportunity to request all of cases in Samadhan Samaroh. Likewise, the DLSs are also, if any party is desirous of resolving the dispute pending before Honorable Supreme Court, whose case has not been identified, he can still, giving me this opportunity to share my feelings on the
coordinated efforts in resolving pending cases through strengthening mediation mechanism and enhancing access to justice. Participants, please.
Honorable Supreme Court, after due deliberation, decided to take action for immediate adjudication towards harmonization across the nation on 21st, 22nd and 23rd August 2026 at the Supreme Court of India, New Delhi, naming it as Samadhan Samaroh 2026, a special Lok Adalat of Honorable Supreme Court of India with an intention to assist parties in resolving their cases through mutually accepted settlement and reinforces Judiciary's commitment to the accessibility in timely delivery of justice. We have seen that litigation is expensive and time consuming. The Honorable Supreme Court of India have decided said Samadhan Samaroh 2026 with a purpose to provide an environment so as to provide relief to the litigants suffering from long-run litigation, encouraging participative justice. Such Samaroh shall be held by the concerned stakeholders with consultations, meetings with government department, public sector units, the respective parties, insurance companies, central authorities of the Central Board of Direct Taxes and CBIT, and with the judges of monitoring committee having pre-sittings with the district legal services authorities and the parties with their counsels after collecting the data from the district level services authorities on cases where these parties have expressed their willingness to settle through Lok Adalat, and in cases where parties have shown their willingness to proceed towards such solution of their disputes or have reached a final settlement agreement, and after preparation of the draft settlement deeds between the parties to be prepared by the DLSs, those shall be countersigned by the secretaries of DLSs, and such deeds between the parties shall be forwarded to the Honorable Supreme Court. After the Samadhan Samaroh, it shall be placed before the concerned judicial sections for procedural record keeping on 21st, 22nd and 23rd of August 2026. Honorable Supreme Court hereafter shall constitute Lok Adalat benches at Supreme Court, providing VC facilities to the litigants and parties holding the said Samadhan Samaroh 2026 as special Lok Adalat. In the state of Odisha, as my brother have already said, the Honorable Supreme Court has identified 1,719 numbers of pending cases in the first phase, consisting of matrimonial disputes, sex bounds cases, criminal compoundable cases, accident claim cases, land acquisition disputes, labor law disputes, and other cases that are suitable for mutual agreement and settlement pending before the Honorable Supreme Court of India. Out of those 1,719 numbers of pending cases, 1,556 number of cases where the state of Odisha itself is one of the parties. The responsibility of the publicity of Samadhan Samaroh 2026 has been based upon the Odisha State Legal Services Authority cutoff. Amongst other modes of publicity, the Odisha State Legal Service Authority, with due approval of the Patron-in-Chief, our Honorable Chief Justice, have decided to have this sensitization program today for the Samadhan Samaroh 2026. in Odisha Judicial Academic Act in the Odisha Judicial Academic Cutter. The process of publicity for Special Locus Adalat at Honorable Supreme Court of India, namely Samadhan Samara 26, in Odisha are as follows. The concerned DLSA will be issuing notices to the parties identified for such solution at first. Thereafter, it shall obtain consent from the parties in the respective consent form. Consenting parties thereafter shall appear at district mediation centers on fixed dates for pre-lok adalat sittings. Pre-lok adalat sittings shall be presided by trained mediators and officials of legal services authorities. In successful recording on settlement format, it will be compiled by the concerned DLSs and will be sent to the Honorable Supreme Court of India. And thereafter, listing of successful matters before the Lok Adalat bench of the Honorable Supreme Court of India shall be placed for final disposal. Honorable Supreme Court of India have specifically pointed out that the parties whose cases are not identified in this first phase amongst 1,107,019 cases can also register in the special website. In addition to that, parties having such disputes before the Honorable Supreme Court can join the special Lok Adalat at any stage, either physically or virtually. In the state of Odisha, as per the rules, all the law colleges have their student legal literacy clubs. Their students, through such literacy clubs, you can assist the Odisha State Legal Services Authorities as well as the Honorable Supreme Court for publicity of Samadhan Samara 2026. We normally know Samadhan as solution in English, but in Sanskrit, as we know, A plus A is equal to A. The word Samadhan means solution in English version, but meaning of Samadhan is to settle or to make a process to settle the long pending disputes through a proper process. Samo means equal and dhan means holding something. As we say that Mr. X is wearing a white shirt, in Oriya it is Mr. X is wearing or paridhanam a white shirt or a vastra. After understanding the reasons of disputes between the parties and proper discussions, process is to be find out an alternate way for settlement of such long disputes. Samaroha we know as festival or a program, just like recently celebrated Raja festival, or like Puraskar Samaroh or award ceremony, Dikhanta Samaroh for just like convocation. But the meaning of Samaroh in the present case is to have a ceremonial program following a process for a good cause after due deliberation. From the epic of Mahabharata, we know that Lord Krishna was the first mediator who on behalf of Pandavas went to the Kauravas for settlement of their disputes between them, asking the Kauravas to share a little part of their land for the Pandavas. But the good sense did not prevail on Kauravas, who refused to share even a small part of their land to the Pandavas. And finally, the famous Mahabharata Yuddha occurred, and the result that we know, neither the Kauravas nor the Pandavas could continue to rule over their land at the time of their lifetime. For the purpose of such settlement, the parties whose cases are pending since long must come to with good senses, prevailing upon them to have an agreement between the parties after due deliberation during the pre-lok adalat sittings, as advised by the Honorable Supreme Court, with the help of the trained mediators and officials of the legal service authorities. If the parties still continues with the same kind of mindset and want to continue with the litigation, there will be no samadhan between them, probably during their lifetime or thereafter. As such, parties must show their willingness for samadhan for such long pending litigation, which are pending before the Honorable Supreme Court for a long period, for which the Honorable Supreme Court have decided to have the Special Lok Adalat 2026. namely the Samadhan Samaraha. It is a responsibility of dear students and all concerned stakeholders to make understand the litigants to settle their disputes through a due process of adequate discussions in presence of all the stakeholders. Mediation, as we all know, is a recognized and alternate dispute resolution system. Thank you and namaskar to all.
For such enlightening words, which focused on the Supreme Court pending matters, role of district legal services authorities as mediation centers, and the necessity for coordination between the
in future, the print and electronic media, distinguished participants, ladies and gentlemen, a very good morning to all of you. The concept of mediation, as we all know, though deeply rooted and ingrained in the Indian culture, duly recognized and practiced effectively, where the peoples of the society with their voluntary participation and taking aid of a facilitator resolve the disputes in a peaceful manner, which in effect percolate a sense of peace and harmony in a civilized society. There has been a gradual shift by passage of time on introduction of the adversarial adjudicatory system, which is regulated and guided by the procedures and the rule of evidence. The empirical data is testament to the explosion of the dockets of our courts of the country and the time consumed in adjudicating the disputes arose between the parties. Alternative dispute resolution mechanism assumes importance not only in reducing the burden of the courts, but providing a structured mechanism or the forum where the parties can amicably resolve the disputes without facing the rigor of the procedural law which regulates the legal proceedings in the courts of the country. The mediation is one of the important facets of the alternative dispute resolution, reinforcing consensual and participatory modes in resolving the disputes. It is cost effective, participatory, and voluntary, embracing the party autonomy system. By passage of time, it was felt not only to recognize the concept of the mediation as a component of the alternative dispute resolution, but to effectuate such notions and give impetus to the same and to provide recognition. The first significant step was taken by the Parliament in restructuring Section 89 of the Codicil Procedure. It gained momentum through a judicial pronouncements and assumed a great importance within the legal framework. The Apex Court in Salem Advocates Bar Association versus Union of India, reported in 2005, Volume 6 SSC, page 344, upheld the constitutional validity of Section 89 and recognized the avowed object and the purpose underlying such incorporation in the said section, and suggested for providing a legal framework to regulate the alternative dispute resolution process, which includes mediation. A further significant step can be perceived from another judgment of the Supreme Court delivered in case of Afcon Infrastructure Limited versus Chariot Warke Constructions Company Private Limited, reported in 2010, Volume 8 SSC, page 24, defining and categorizing the dispute which comes within the folds of the mediation by reaffirming the legislative aspiration. Thus, the mediation has evolved not only through a legal provision, but also through judicial initiatives. Another significant step to strengthen the mediation as one of the effective tools within the ADR mechanism is by enacting a Mediation Act 2023. The said act not only promotes the mediation, but gives recognition to the party autonomy and the settlement arrived in fair, transparent, and voluntary participation of the parties. The doctrinal values thus engulf the mediation as important, significant, and an integral part of the Indian dispute landscape to work within the structured framework as supplementary to an adjudicatory system without disturbing the core fabric of the adversarial adjudicatory system, and in such a way it cannot be perceived to supplant the same. The eminent mediator Joseph Greenbaum observed that an ounce of a mediation is worth a pound of arbitration and a ton of litigation. Though the ADR mechanism have a variety of the components like an arbitration, mediation, lok adalat, and negotiation, yet the judicial scholars in their wisdom gained from the experience and the empirical data suggested to integrate those components to strengthen the ADR system and opine that even in case of an arbitration being one of the component of the ADR, the mediation can also play a significant role, and that is how the concept of med-art evolved. To give a further impetus to the mediation, a significant step has now been taken by the Supreme Court of India in organizing a special Lok Adalat as Samadhan Samaharo. The word Samadhan is not to be understood in a generic sense, but given such name, which conveys a laudable message from the expression, and the Supreme Court has coined this word Samadhan from the Supreme Court action from mediated adjudication and disputes harmonization across nation. That is what the Samadhan has come. The Honorable Chief Justice of India, being pioneer of such initiatives, have envisioned to create a synergy between a mediation and a lok adalat, both being the integral part of the ADR system, yet wanted to integrate like a MEDA to a Med Lok Adalat. The concept of this Samadhan Samaharo was actually envisioned by the Honorable the Chief Justice of India way back in the month of April 2026, where the cases which are pending in the Supreme Court of India concerning our state, the figure has already been said by Justice Pathak. The Supreme Court wanted that there are certain litigations which are amenable, or there is a possibility of a settlement through a mediation, and to give some kind of a legal recognition, the Lok Adalat was also thought of to be organized so that it will have a sanctity of a legal bindingness. as we all know, that the mediation is a party-centric, where the parties who are there take a control of the entire proceedings with the help and aid of a facilitator whom we commonly know as the mediator. The mediator really acts as a catalyst between the parties to open up the dialogue, to say what their right which they have in relation to such disputes, and what could be the amicable solutions which could be found out so that such dispute can be set at rest in a more peaceful manner. The mediation not only brings an end to a dispute, but the most significant part of the mediation is that it fosters the peace and the harmony between the parties. As we all know, that the moment the dispute cropped up, the first and foremost thing which happened to a parties that they do not interact with each other, and there is a complete stubbornness in them. The role of the mediator assumes importance as he facilitates the parties to open the dialogue. The moment the parties interact with each other, there are many things that would come out, and therefore there is every possibility that the disputes which is there for so many years may be brought to its logical end through an amicable mechanism. The mediation, as we all know, is not a origin of a recent time. The Indian cultures have been embracing it since the ages. One of the illustrations was given by Justice Pathak regarding the Mahabharata, where the Lord Krishna played the role of a mediator and wanted to resolve the disputes. There cannot be any growing apprehension in the minds of a people that once they come for a mediation, they would suffer. It is they who controls. And if they think that there is no possibility of solutions to be arrived, there is no compulsion to continue. They can simply walk out from the mediation. It is one of the mechanisms by which the parties can explore the possibility of amicable solutions, which is definitely within their competence, and therefore the parties should not shy away from interacting with each other and put themselves into a mediation. We all know that there are a lot of litigations which are pending in the docket of the court, including the Supreme Court, which involves the government or its departments. The Honorable Chief Justice of India has for the first time taken up an initiative in structuring this Samadhan Samaroh in such a robust manner where all the departments of the governments were requested to appoint a nodal officer so that any dispute relatable to their department, they would be in a position to negotiate, they would be in a position to find out a solution, they would be in a position to put end to a litigations which is pending for years together. All the nodal officers, as I am told, are physically present here. My request to all of them that please participate with an open heart. Do not carry any kind of an inhibitions. Do not carry any kind of obstructions. If you can resolve the disputes, I think this will be the best service which a person can give to the society. The Supreme Court have also appointed a committee consisting of 5 honorable judges who will be adorning the bench of the Special Lok Adalat that would be organized on 23rd, 24th and 25th of August. They have also set up a coordination committee of the registrars of the Supreme Court, and they have also provided the forum where the parties can definitely apply and show their willingness to participate in the mediation process. This is the first time that the mediation is been considered along with the Lok Adalat. We should embrace this notion and do not think that it is simply an idle exercise or would remain a dead letter. I think all the government departments, the nodal officers, and all the litigants whose cases are pending in the Supreme Court would definitely they show a cooperation so that this mediation process or the mechanism which has been adopted by the Supreme Court in this regard becomes a successful. I congratulate once again to the government for appointing the nodal officers who will definitely play a very important role in the success of the mediation. You also know, so far as the mediation is concerned, the Honorable Chief Justice of India is now visiting the United Kingdom recently, and the Indian High Commission on 10th of June organized a program where the Honorable Chief Justice of India very aptly conveyed our nation's commitment towards the mediation and sensitization and the widespread publicity which have been made to make this mediation a very successful tool. In these words, and I quote, I can say proudly that in India, in every street, in every town, in every village, people talk about mediation, people understand mediation, and people prefer mediations. Thank you all.
Valuable experiences. His Lordship's address has also added value to the program in the sense that
My question today is, actually, in the Samadhan Samaroh 2026, how does the judiciary plans on ensuring that rural or unrepresented litigants are not left behind due to the existing digital divide?
This Samadhan Samaroh is really in relation to matters which are pending before the Supreme Court. So first thing is they must be represented by their lawyer, and their participation is also there. So far as the virtual appearance is concerned, I believe that we have already set up the infrastructure in this regard at the taluka level or at the level where they are residing, so that they can virtually attend at the time of the special
Hello.
and even at the remote points, if they are unable to come to a main places or a sada, still we have done and put those infrastructures. So there cannot be any apprehension in the mind that they will be denied of their virtual appearances in course of that particular proceedings. And second thing is that so far as the mediation is concerned, it does not really prohibits any lawyer to appear. Rather, it encourages that lawyer should also be there along with the party. So to take care of their best interests.
Yes.
Members of the bench. I am Shrimay Mahapatra from University Law College, Utkal University. So my question is, since ADR aims to encourage open dialogue and voluntary participation, do you believe that the increased use of regional language can help parties to communicate more freely, thereby strengthen the effectiveness of mediation and other ADR process?
There is no difficulty, but languages or the regional languages would be the best to communicate, because the party may be more confident in sharing their experiences or percolating their problems. So in that event, I do not find any kind of a obstacle in this regard why the regional or the local languages will not be embraced. Rather, it should be more encouraged so that the parties can openly share what is passing through their mind to have the amicable solutions of this. And I do not think that there is any kind of a restrictions which have been put anywhere that it cannot be done in a local languages. Even I can speak in Hindi and say that कहीं पे भी कोई ऐसा obstructions नहीं है जिसके अंदर में आप हिंदी में या उड़िया में या किसी भी अपनी लोकल भाषा में आप नहीं कर सकते। कम्युनिकेशन जब किसी चीज का आप करते हैं तो आप एक भाषा को एक प्रयोग में लाते हैं कि इस भाषा के माध्यम से हम अपने एक्सप्रेशंस को कैसे हम लोगों को पहुंचा सके। तो मेरे हिसाब से रीजनल लैंग्वेज या लोकल लैंग्वेज सबसे अच्छा तरीका है कि अपने को एक्सप्रेस करने का दूसरों को। I think you got the answer.
Yes, sir. Thank you.
Of Samadhan Samaroh is the doorstep delivery of justice. However, an institutional challenge often arises post-compromise, where litigants face bureaucratic delays in the actual execution of the Lok Adalat award, especially when state instrumentalities are involved. Since a Lok Adalat award holds the finality of a civil court decree, are there specific fast-track mechanisms or compliances frameworks or administrative tracking mechanisms being established under this initiative to ensure that the Samadhan results in immediate material relief?
Your question is based upon Section 21 of the State Legal Services Authorities Act, or the
Yes, sir.
Legal Services Authorities Act. If you look at subsection 2 of Section 21, it says is final and binding on the parties. And there is no appeal which is provided against that particular award passed by the local level. Second thing is, it all depends upon a mindset. Can you conceptualize a thing that once the parties across the table has come to a particular settlement, can they rescind or retract therefrom? I think possibly it should not be, because it's a freedom which is already in them, whether to agree or not to agree. Once they have agreed, then what we feel is that they must honor the terms and conditions which they have agreed upon. And in order to eradicate this kind of a confusion or an apprehension in the mind of the litigants, this is the first time an initiative has been taken by the Supreme Court to request each department of the government to appoint a nodal officer. If the nodal officers are there and if the settlement has been arrived, I do not think that there will be any kind of a I think resile from the agreement which they have already arrived at. Though you say that it is like a decree passed by a civil court executable under Order 21 of the Code of Civil Procedure, which is again putting the entire thing into another arena. Yet I believe when these initiatives have been taken for the first time, I don't think that there can be any kind of an apprehension in the mind of the litigants that it will not be honored.
Thank you, sir.
Section 80 of the Mediation Act 2023, it stipulates a time period of 120 days from the date fixed to the first appearance of the mediator, and as extra 60 days of mediation approved by the court. However, an official statistic and a routine observation, we can see that the number of cases which are unsuccessful are more than the number of cases which are successful. some parties do not have a genuine intent to compromise on this, or are very stubborn on keeping their ideas fixed. So, as per the administrative perspective or judicial perspective, what steps can we do in order to ensure that the capacity of this institution can be reserved for those cases in which medicine is successful and it is much more viable?
I think every failure taught us such certain lessons, and we always take it as a further challenge to improve the system. As I already said, that so far as the mediation is a party-centric and a party autonomy is also there, the mediator does not take part in the mediation as an adjudicator. As I already in my speech have said, that he acts as a facilitator, simply facilitating or fostering the open dialogue between the parties. Now, willingness is one of the important factors. If a litigant does not think that he will settle the dispute through this mediation mechanism, there is no compulsion on him to go for a mediation. It is what is a willingness which is very important in the mediation system. Once he shows his willingness, I do not think that there is any possibility that he has come with an intent of not settling the dispute and simply wanted to delay the process. There is a timeline which is already there, and if the mediator finds that there is a possibility of any settlement, the mediator can definitely give or foster more dialogues amongst the litigating or litigating parties. And I believe that the success should not be measured on a numerical number or a percentage basis. The success should be measured that how effectively we can put a particular system in place. And I hope that the history will definitely say that how the mediation has really changed the entire legal framework in future. I believe that the day will come, and I'm very optimistic in this regard.
Thank you, sir.
Krishnaram Mahapatra, Judge, High Court of Odisha, and Chairman of High Court Legal Services Committee for his support. Without his lordship's support, it would have been very difficult to organize such grand and useful program. We will seek his kind help for organizing similar program in future. I'd like to thank all honorable judges of Odisha High Court for blessing us with their kind presence. I am very much thankful to Learned Registrar General and officers of Registry, High Court of Odisha. They paid attention to every detail of this program from the moment of preparation began a week back till end. Learned Director and officer and staff of Odisha Judiciary Academy for their kind support to make this event successful. Like many occasions in this past, this time they have also extended the whole support to us. We hope this will continue in future. Principal Ella and both additional secretaries of Law Department of Government of Odisha, there are hidden commandos. They did their best to help us at every critical juncture, and they have become successful in most of their missions. And principal secretaries and nodal officers of these different departments of Government of Odisha, in fact, they are holding wheels of success of our vehicle of Samadhan Samaro. Their sincere effort will help us to dispose more cases at the completion phase of Samadhan Samaro. Secretaries, District Legal Service Authority, Cuttack, Puri, Jagatsinghpur, Honorable Venkana, for attending this program physically. Learned faculty members and law students of premier law institutions of our state, like National Law University Odisha, Madhusundara Law University Cuttack, PG Department, Law, Utkal University, Banibihar, Law Department, BJP Autonomous College, and University Law College, Bhubaneswar. In fact, law students, those are present here, displayed a gold standard of discipline, and very patiently they heard us. Such discipline will give them success in every future, in every sphere of their life in future. Learned Secretary, District Legal Service Authority, panelers, legal and defense counsels, and paralegal volunteers of all districts of our state who have joined us virtually to make this program successful. I convey my special thanks to Additional Chief Secretary, Director, INPR Department for giving support for this program, as well as for wide circulation for the event of Samadhan Samarah. So also special thanks to Doordarshan and their crew. They gave Odisha Legal Service Authority a thrilling experience about the direct telecast in Doordarshan. On this occasion, we also thank members of print and electronic media. Our heartfelt thanks to all of other well-wishers who have directly or indirectly helped us to make this event successful. Thank you and namaskar.
मु अरविंद पट्टनायक सदस्य सचिव राज्य आईन सेवा प्राधिकरण कटक। साधारणतः सुप्रीम कोर्ट व सर्वोच्च न्यायालय रे कौन प्रकार लोक अदालत हुए ना, मात्र मान्यवर सुप्रीम कोर्ट एथर निष्पत्ति नहीं 2026 रे गोटे लोक अदालत हम। एथिरे सुप्रीम कोर्ट जो सब मामला गुड़िक पड़ रही जो मामला गुड़िक चली रही ताहार समाधान लोक अदालत एवं मध्यस्थता व मेडिएशन सहायता एगुड़िक फैसला तार प्रक्रिया चली। बर्तमान से सब केस गुड़िक निर्दिष्ट भाव में निरूपण करा प्राय आमर 1527 मामला अच्छी जो सरकार पक्ष अच्छा प्राय 127 मामला अच्छी जो कि बेसरकारी पक्ष मामला अच्छी। से उभय मामला गुड़िक बर्तमान समस्त पक्ष मान को नोटिस दि जाएगी से गोटे मिलामिशा हे एवं जदि से मिलामिशा समाधान हुए सुप्रीम कोर्ट अगस्ट मसरे यही केस गुड़िक लिस्टिंग होकर फैसला करा यार मूल लक्ष्य हूँ जे न्याय समस्त द्वार देश पहुँचू एवं विवाद लिप्त थिबा व्यक्ति से जो विवाद निष्पत्ति से निजे सहयोग कर निष्पत्ति नियंतु यह ही तार मूल लक्ष्य एवं यह द्वारा जनसाधारण मंगल हो बोली आशा कर। धन्यवाद।
हम लॉ वेरियस लॉ स्टूडेंट्स डिफरेंट कॉलेज से पार्टिसिपेट करते गवर्नमेंट थ्रू वेरियस डिपार्टमेंट सेक्रेटरी जो मैंने नोडाल अफिसर नियुक्त होती सहित आम लॉ सेक्रेटरी उपस्थित थे एवं जहाँ समाधान समारोह प्रोसेस जो आम रही सुप्रीम कोर्ट जो लोक अदालत आयोजन करा आगामी अगस्ट 21, 22, 23 तारीख हम तापाई सुप्रीम कोर्ट बहुत गुटे केस आइडेंटिफाई कर आमर ओडिशा आमर 1719 केस आइडेंटिफाई करा एवं से केस गुड़ाक जितेबाला हाईकोर्ट को सुप्रीम कोर्ट इंटीमेट कर हाँ ये सुप्रीम कोर्ट गोटे एसओपी कर टाइमलाइन फ्रेम कर जो प्रोसेसटा एप्रिल 21 तारीख आरंभ होती जुलाई 31 तारीख से आइडेंटिफिकेशन हम तार प्रोसेस हूँ प्रथम आम जिते केस गुड़ाक पाइलु सुप्रीम कोर्ट जो केस गुड़ाक ओडिशार केस पेंडिंग अच्छी सब कैटेगोरी केस समाधान हो पार ना मैट्रिमोनियल केस बैंकिंग केस सर्विस मैटर लैंड एक्विजिशंस जो केस गुड़ाक समाधान हो पार से सुप्रीम कोर्ट नोटिस आमको लिस्ट देलापर यार प्रोसेस हूँ आमको नोटिस इश्यू कर पार्टी को तो ये पार्टी मैंने कौटी आइडेंटिफाई हे आम पेटिशनर जो पक्ष केस करी तार आड्रेस नहीं कि आम डिफरेंट 30टा जिला आम ओडिशा रही 30टा जिलार जो जिला आईन सेवा प्राधिकरण रही से जो सेक्रेटरी अच्छा तत्वावधान में अंडर द डायरेक्शन एंड सुपरविजन ऑफ द सेक्रेटरी ऑफ द डिस्ट्रिक्ट लीगल सर्विस अथॉरिटी एगुड़ाक प्री लोकल अदालत सिटिंग हम। प्री लोकल अदालत सिटिंग कौन होना प्रथम पार्टी को नोटिस करा सहित गोटे कनसेंट मेमो दि जाइए। कनसेंट मेमो रे पार्टी प्रथम राजी होगा दरकार से गोटे लिखिक देव फॉर्म रे जे आम यही समाधान समारोह जो स्पेशल लोकल दूचे एम राजी कनसेंट मेमो पाई सारा तापर गोटे डेट फिक्स कराई जो थे कि बहुत पार्टी प्रेजेंट रे से फिजिकाली प्रेजेंट रही पारे चाहिए से भर्चुअली प्रेजेंट रही पारे एवं तांका भितर मेडिएट करने आम कंसलिएटर मतलब एनगेज अच्छा डीएलएस सेक्रेटरी जी आम जुडिशियल ऑफिसर सी भी एनगेज हो पारे कन्स करेंगे ता सहित ट्रेन मेडिएटर जो मध्यस्थता कर एनगेज होती से भितर आमिकुल सेटलमेंट आपस समाधान माध्यम किमी जो लिटिगेशनटा अच्छी समाधान कर चेष्टा कर जो केस गुड़ाक समाधान हो पारा सेटलमेंट गोटे तार फॉर्म भी सुप्रीम कोर्ट फॉर्म कर सेटलमेंट डीड से साइन कला उभय पक्ष साइन करेंगे आइडेंटिफिकेशन प्रकृत से लोक ना ना आइडेंटिफिकेशन डॉक्यूमेंट आधार कार्ड कि भोटर फोटो आइडेंटिटी कार्ड एनी डॉक्यूमेंट ऑफिशियल डॉक्यूमेंट देलापर से सेटलमेंट फॉर्म में साइन करेंगे जो डीएलए सेक्रेटरी आम अच्छे प्रति जिले में से फॉर्म सेटलमेंट मेमो को स्टेट लीगल सर्विस अथॉरिटी हाईकोर्ट को पठेबे समस्त एप्लिकेशन पाई सारा पर जुलाई 31 सुधा जी एप्लिकेशन पाइबू सेटलमेंट डीड पाइबू जो पार्टी वो पक्ष राजी अच्छा से गुड़ाक आम सुप्रीम कोर्ट को पठेबू वन सुप्रीम कोर्ट गलापर सुप्रीम कोर्टर जो आम वन स्टॉप सेंटर बा वार रूम सेटअप करा से केस गुड़ाक आइडेंटिफाई रिसीव कलापर से बेंच जो कन्स्टिट्यूशन बेंच आम हम 3 दिन लोकल हम सुप्रीम कोर्ट 21, 22, 23 तारीख अगस्त 21, 22, 23 से लिस्टिंग कारण सुप्रीम कोर्ट हाईकोर्ट केस लिस्टिंग कराए से गुड़ाक लिस्टिंग से दिन जो दिन से केस लिस्टिंग से दिन कनसर्न पार्टी को जो पार्टी मैंने राजी सेटलमेंट वेब लिंक दिज्व आम जो लिंक भिसी लिंक दिज्व से भर्चुअली जॉइन करेंगे मैंने ये गोटे सुविधा बाट हो पार्टी को सुप्रीम कोर्ट जावाक पड़ूनी सुप्रीम कोर्ट भावतु पार्टी पाक लोक पाक आसी पार्टी तार जिले में रही प्रति जिले में घरे रही एवं सुप्रीम कोर्ट रे लिस्टिंग केस है भर्चुअली से जॉइन कर आपण मैंने जानी रखुँ जो आम प्रत्येक जिले में जो डिस्ट्रिक्ट लीगल अथॉरिटी रही डिस्ट्रिक्ट कोर्ट रे आम भिसी लिंक फैसिलिटी रही प्रत्येक पार्टी चाहिए से भिसी लिंक से जॉइन करेंगे डायरेक्ट सुप्रीम कोर्ट रे तत्वावधान केस जो लिस्टिंग हो
मो ना हूँ डॉक्टर पवित्र मोहन सामल सेक्रेटरी लॉ आमर जो समाधान समारोह प्रोग्रामटा है से प्रति डिपार्टमेंट गोटे गोटे नोडाल अफिसर को आम सिलेक्ट कलु एवं आमर डिपार्टमेंट गोटे लोक आमर ऑफिसर को स्टेट पे आम गोटे नोडाल अफिसर करना वर्तमान आम प्रतिदिन सिटिंग करी पाखापाखि 100 केस को आम स्ट्रीमलाइन को आनीदेलु एवं आम पाखापाखि टार्गेट रखु 500 केस सारू जोटा कि 1556 केस आमर आइडेंटिफाई होती ओडिशा पाई आउ एटा गोटे स्वतंत्र लोक अदालत जोटा कि सुप्रीम कोर्ट रो प्रथम लोक अदालत कहले अत्युक्ति हम ना जोटा कि आम एटा गोटे बहुत सुवर्ण सुजोग एवं आम समस्त डिपार्टमेंट प्रोएक्टिवली काम कर ऑनरेबल आमर चीफ सेक्रेटरी गोटे बहुत इंटरेस्ट नहीं कि आमको समस्त टीम वर्क करुँच मु भावुची सुफल फलप्रद हम आम
मु डॉक्टर भाग्यलक्ष्मी रथ रजिस्ट्रार जनरल ओडिशा हाईकोर्ट आमर सुप्रीम कोर्ट को जो अभिन्न प्रयास रही समाधान समारोह सुप्रीम कोर्ट को पाखे जो जो केस सब एवं अच्छी तार गोटे संख्या से माने हमको केस गुड़ाकर सब डिटेल देइचंती हाईकोर्ट को जो थे कि हाईकोर्ट गोटे प्रमुख भूमिका आम रोचे ताधे जे गवर्नमेंट रे जो थी गवर्नमेंट होचंती हमर ओडिशा गवर्नमेंट होचंती दी लार्जेस्ट लिटिगेंट बोली आम कहू बहुत केस आइदर गवर्नमेंट फेवर रही माने गवर्नमेंट जो थे पार्टी होता एगेन्स्ट हो तेणु ये मुख्यतः गवर्नमेंट केसेस गुड़ा को आम बेसी स्ट्रेस दौचु अकॉर्डिंग टू सुप्रीम कोर्ट को डायरेक्शन प्रकार जो थे आमर लॉ सेक्रेटरी सहित प्लस आमर जो ओडिशा स्टेट लीगल सर्विसेज अथॉरिटी अच्छा ये समस्ते आम मिसिकी हाईकोर्ट आनुकूल्य आम सुप्रीम कोर्ट निर्देश मुताबक विभिन्न प्रकार स्टेप जो जो गुड़ा कहुई केस केमती आइडेंटिफाइड हम आउ पार्टी मान को केमती नोटिस करा जीवो पार्टी माने किभली भाबे भर्चुअली हो बा फिजिकली हो से माने आसिकरी अटेंड करि परिबे तांको मीडिएटर आमे दउचु सुविधा मध्य दउचु आमर डिस्ट्रिक्ट लेवल जो डीएलएस सेक्रेटरी माने अछंती से माने एथरे प्रमुख भूमिका तांकर रहउची पारालीगल वॉलंटियर पैनल एडवोकेट ए समस्त को सांगरे धरिकी विभिन्न जिला स्तर रे पार्टी माने जोठी अछंती ओ गवर्नमेंट ऑफिशियल माने समस्त को धरिकी गोटे समाधान व्यवस्था करा जाउची आमे आशावादी जे आगामी दिन रे गुड़िए केस ए माध्यम रे हुए आमे सारी पारिबु जोटा कि बहुत बड़ आमर कंट्रीब्यूशन रहिबो समाज को कारण जहार केस टी हुए सी लोकटी एका नुहे तार एंटायर फैमिली से माने गोटे कष्ट भितर देकी जाती तेणु जेहेतु बहुत केस से कला परे परे अपील करी करी से सुप्रीम कोर्ट को बर्तमान जाइकी पहुँची तेणु से लेवल जो गुड़ाक सुटेबुल केस सच एज मोटर एक्सीडेंट क्लेम ट्रिब्यूनाल केस गुड़ाक है मैट्रिमोनियल डिस्प्यूट है सर्विस मैटर है जो जो गुड़ाक माने योग्य मेडिएशन पाई मध्यस्थता करिके सेटा करी हबो सेटा को आमे किभली भाबे समाधान करिकरी ताकू समाप्ति करिपारू से केसर सेटा पई हमर ओडिशा हाईकोर्ट तरफरु विभिन्न प्रकार आमे पदक्षेप नौचु। आज गोटे सेमती पदक्षेप थिला जो थरे कि आमे पब्लिक अवेयरनेस समाज रे सेटा गोटे सृष्टि करिया पई एभली गोटे प्रयास सुप्रीम कोर्ट कर अछि बोली आमे जणिया पई आज एमती गोटे वर्कशॉप करथिलु जो थरे लॉ स्टूडेंट नोडल ऑफिसर जो गवर्नमेंट रे अछंती आ विभिन्न स्तर रो लोक आसिकरी एथरे भाग नैथिले आमर ऑनरेबल चीफ जस्टिस ऑनरेबल अदर जजेस ऑफ द हाई कोर्ट समस्ते से प्रयास भितर समस्ते थिले एवं सुंदर भाव क्वेश्चन आंसर सब दिया निया हला जो थरे कि बहुत गुडे डाउट जो मानक मन रे थिला सेटा आज क्लारिफाइड हे परछि। आ मु भाबुची ए प्रयासटा आमको बहुत आगो को नबो एवं अधिक रु अधिक केस आमे जेमती समाधान सूत्र रे आमे समाप्त करि पारिबो।